Good morning, everyone.
Good morning.
Good morning.
Thank you. We just had to wait for the live connection with YouTube, and it's on right now. Let me introduce the case we have next. It's case number 123707 in the interest of E.L., a minor child. Let me get the appearances in this particular matter. Please state your appearances for the court.
I'm Jordan Kiefer, Your Honor, appearing on behalf of the appellant mother, B.S.
Okay. Appearing for the state.
Assistant District Attorney Julie Kuhn on behalf of the state.
Thank you very much. And before I really get started, the other judges are here with me are Amy F. Klein and Judge James Burgess. This case has been set for 15 minutes. I'd like to ask the appellant, whether or not you want any rebuttal time.
Yes, I'd like to reserve 3 minutes, please.
And are there any other things that we need to discuss before we get started? If not, the appellant, we're ready to hear your argument. Thank you.
Thank you. May it please the court. This case presents a somewhat unique and really truly complex set of facts. It involves very young parents. It involves a contemporaneous criminal case that was proceeding at the same time. It involves the global pandemic that we've been dealing with and how that affects state cases as they try to proceed. And then it also implicates the heightened standards that we have under the Indian Child Welfare Act. So a lot of different things are at play to make this case really challenging and unique, I believe. So, whenever we look at it first, kind of from this ICWA perspective, ICWA really requires more evidence, more scrutiny, more attention on two pretty key points that are relevant to this particular case. And I believe that the state failed to give it this heightened consideration on both of those relevant counts. So first, ICWA requires evidence beyond a reasonable doubt of unfitness of the parents. And that evidence is also supposed to be supported by qualified expert testimony indicating she is to remain in the custody of his or her parents. And here we just did not have the evidence rising to the level of a reasonable doubt. The court really emphasized mother's failure to provide an explanation for another child's injuries without really recognizing that mother was very limited in her ability to address that topic because of that simultaneous ongoing criminal case and mother's right to protect herself against self-incrimination. So
Counsel, let's talk about that issue because that's a pretty important one.
Sure.
And I know you rely pretty heavily on the Brown case in making your argument that essentially the court was requiring your client to choose between her constitutional right to her child and her constitutional right to not have to self-incriminate. But let's talk about the part that therapy would play in this analysis, because I know the Brown court cites to some cases from other jurisdictions that kind of break it down and say it's one thing to require a parent to admit that they injured their child in a court proceeding, but it's kind of another to say, look, you need to address this in therapy and talk to your therapist about that. Can we agree on that aspect?
yes.
Okay, so talk to me about the therapy component here, because I'm not finding that we had much cooperation by your client to participate in therapy or talk about the issue in therapy. And to me, that's the important distinction. And so can you talk to me about your position on that point?
Sure, that's a fair comment. And I think that my client's testimony at trial indicated that she actually did participate in therapy for a time and then ran into difficulty in continuing to be able to pay for that therapy. And that actually relates to that active efforts discussion that we have a little bit later on in our brief, and that I know is kind of a source of contention in this matter as well. and that mother really felt like she wasn't getting enough assistance in being able to continue that therapy. So as with many other aspects.
Didn't she also testify that she quit because she didn't like the fact that they kept talking about the other child who was injured, and she didn't really want to talk about what happened to the other child in how that situation needed to be addressed? I mean, that was the point. That's why she went to therapy, was to talk about the other child, correct?
I'm sure that it was probably part of it, but I think that therapy is often ordered as just kind of part of a generic case plan. I think there are very few distinct cases where therapy is not recommended, or at least a mental health intake with the recommendation that parents follow the recommendations of that intake. So that having therapy in this case wasn't necessarily unique to those circumstances, in my opinion.
You don't think therapy? Do you think it was necessary? I'm sorry, go ahead.
I'm sorry, you said it was not unique, but do you think in a case like this, it was important to engage in therapy?
I think in almost any distinct case, it's likely important to engage in therapy, but,
Okay.
Of course, tailored to the circumstances at hand.
And so, I mean, just to be frank, that's what I'm struggling with your position, because we've got the agency testifying that they're, giving your client options for no cost therapy or sliding scale therapy. Like if she, because she did say at one point she couldn't afford to go. So they provided her some options to continue. And it just seems in the testimony that she was very resistant, not only to going, but to actually addressing what she was sent there to address.
I understand that position, but I do think that there is kind of a prevailing sense throughout a lot of the testimony. And again, I wasn't trial counsel, so I'm kind of in the same situation that many of you are, and that I'm trying to interpret, the feel of some things from just a reading of the transcript and conversations with my client, of course. However, I have certainly gotten the sense that there was a lot of lack of organization and communication between the St. Francis workers and the tribal workers. Undoubtedly, that was really complicated by the pandemic, but I think that all of those challenges really made coordination of services and communication even more challenging than they normally are. And I know that, we also have mother testifying that she would have continued in therapy had she gotten more assistance. And I think you have to kind of weigh all of those things against each other here. Any other questions on that point before I proceed? Well, kind of continuing on with this thought that mother had a constitutional right that was sort of up against her right to parent her child. You're right that I do. I don't know that I would necessarily say I rely heavily on Brown, but I do think that Brown can at least be instructive, because the court there was looking at those surrounding circumstances and how they might affect a parent's either confession or ability to proceed in one case over the other, where we have kind of the Sophie's choice of competing constitutional interests. And while in Brown, they were certainly on the other side of that in the criminal context, I do think that it's at least instructive here to say, we appreciate that that is something that can create undue pressure on the parents and will affect how they might engage in one case as opposed to the other. And, we've had other cases with other panels of this court where they have found that where, circumstances that really affect the termination might be mitigated within maybe 6 months, that termination is not yet appropriate. And I think that here, there's some similarities. If that criminal case had been permitted to proceed and the parent could have protected her constitutional rights there, and then been able to let that, sort of guide her decision later in the child case, or rather, be able to proceed in the child case without worrying about that same concern, we might have been able to mitigate that same concern as well within 6 months. So from a foreseeability perspective, I think that is very challenging in this case as well. The other, kind of big point that I think that ICWA raises in this case is this question of active efforts. And we've talked about that already a little bit in connection with the therapy and everything. But as this court is aware, we have these guidelines from the Bureau of Indian Affairs, and they're not exhaustive, but they do provide some guidance for us in how we should view what constitutes active efforts. And we don't have a lot of guidance elsewhere in Kansas. We have very limited case law on what active efforts really means. So I think if we look at it from a very practical standpoint, if it's a heightened standard, we know that it has to be something more than the reasonable efforts that we typically see in a sync case, right? The antonym of active would be passive. So something more than passive efforts. And we have this nice language from the Ninth Circuit that kind of illustrates this idea of passive efforts, and that those would be sort of the typical, we've drawn up a case plan for the parents. Here's what you need to complete, and then waiting to see what the parents are able to do with that. We know that ICWA really requires more than that. And I know that the state references, kind of this idea, should the workers have taken mom by the hand, and done more for her. And I do think that on some level, yes, that is required. We need more than those passive efforts for parents in these circumstances. And those active efforts really need to be tailored to the individual circumstances at hand. Here we had very young parents.
You're asking for active efforts on behalf of the state, but say maybe take mom by the hand and lead her to where she's going. Isn't that a passive effort on her part?
On mother's part?
Yeah, wouldn't that be a passive effort? Shouldn't there be some evidence of her wanting to embrace change and actively participating in this rather than being led around to what
Sure.
But
I think that there is ample evidence in this case that mom was actively participating. When we look at the worker's testimony, we have, her home-based supervision officer who says she was incredibly compliant, that she did everything that was asked of her. We have numerous case plan tasks that were completed.
That supervision officer was from a different case, correct? It wasn't from this case.
Correct.
The worker from this case testified mom wouldn't even let her in the house.
I think that housing was an issue, but then we also had testimony that mother was incredibly engaged in visitation, that she consistently engaged in any participation that was made available to her, including, acting appropriately in that visitation, bringing appropriate things, which, as this panel knows, is more than many parents who are much more mature and more experienced are able to accomplish under similar circumstances. So, she had employment, she was working on housing. There are a lot of things that mother was doing to try to actively engage in this case, but the burden is on.
The housing she was working on was she moved in with dad, who she had a no contact order with, right?
I believe that was alluded to at some point, but I'm not sure that the evidence ever really bore out exactly.
I mean, his name was on the lease. She denied it, but his name was on the lease. There were male clothes and male deodorant and male items in the apartment. And she still continued to deny that she had contact with him. I mean, it seems to me that how's the state supposed to work with somebody who is not being truthful with them about, their substance abuse issues, who they're even living with and associating with, and if they can't even let them in the house? I mean, it seems to me that the state, obviously they're required to engage in active efforts, but what's the obligation on the parents' part to meet them at least halfway in that respect? Let them in, show them, here's the home I want to bring my child to, here's who I'm hanging out with, here's the therapy that I'm engaging in. I mean, that's the other issue I think we've got here in terms of the active efforts, is it's not a one-way street, is it?
No, certainly not. And like I said, I do think that there is evidence that mother was actively engaging. Certainly the housing might be a shortcoming, but again, if we consider the age of the parents who are implicated in all of the other circumstances that are surrounding, I have questions about whether or not mother truly appreciated the impact of those choices. And I wonder, if the workers have been more willing to engage in that conversation with her. Again, we have multiple workers, we have the tribe, we have St. Francis, we have different case managers, lots of different information. Frankly, I think that the record indicates often conflicting information, especially on the topic of visitation and what that might look like. But when we have that conflicting information in different workers and a young and experienced parent, I'm not sure that we can put all of our eggs into the basket of mom didn't cooperate on this one issue of housing when we have a parent who was clearly trying to cooperate in many other facets of the case. And like I've said, mother was really making this effort to participate in visitation that was available to her. And, we have quite a bit of testimony from multiple different workers in this case that the type of visitation that was being provided is not adequate for a case that is deemed with a goal of reintegration. The DCF
Well,
guidelines
let me ask you a
themselves.
question. This came
Yes.
under the Indian Child Welfare Act. Did your client, there are provisions within that act to decline Indian Child Welfare Act jurisdiction. Did your client ask for it? Did she consent to it? I mean, that complicated the visitation when the Indian Child Welfare Act came into place and they placed with an Indian family in Oklahoma. That complicated it. If there hadn't been consent or agreement to the Indian Child Welfare Act jurisdiction, visitation might have been, placement might have been in Wichita. So was she on board with the Indian Child Welfare Act jurisdiction?
Your Honor, since I was not trial counsel, I'm not aware of whether or not she consented or what her position was at that time. She is very much aware that having the tribe's involvement has complicated this case. I think, again, the pandemic and all of the different issues presented by that has certainly further complicated this case and presented additional challenges, to visitation. And frankly, I mean, ICWA does apply. Even if she could have waived it back then, that's still sort of the standard that we're faced with now. And I think that the active efforts with regard to visitation simply doesn't measure up to that standard that we have to look at here.
What else are you saying that the agency should have done in terms of visitation? I mean, it's my understanding that when the tribe wouldn't transport the child more than once a month, that there was an offer to pay the parents transportation costs, or then the agency stepped in and arranged for remote visitation. I mean, that was the initiative that they took to, step up and set up remote visitation, which is not ideal. But I mean, when we're faced with the pandemic and travel bans, I mean, what else are you saying that they should have done in that situation?
Well, the evidence in the record only indicates an offer to reimburse parents for gas if they were to find themselves a ride there. And again,
actually she testified at trial that I remember counsel said, well, what about, it was just gas, they don't have a car. And she said, no, it was travel expenses, wasn't it? She also said it was travel expenses. I mean, yeah, they didn't have a car and that's difficult, but they didn't ask if they would reimburse rental car expenses. I mean, that would have been travel expenses, right?
I suppose, but in this situation, the parents were actually too young to even be able to rent a car. And again, I think that kind of relates back to this idea that we have very young parents who kind of needed that individualized approach. And they certainly demonstrated they were actively engaging in any visitation that was available to them. So there wasn't necessarily a concern that if they had had more visitation available, that they would not have made use of it. Really the opposite is true. I think they would have made use of any visitation that they were able to. And again, I suspect that due to the parents, young age, that really presented some unique barriers to them being able to provide their own transportation. Here, that's where we needed those active efforts to step in a little bit more. I don't know whether or not a worker suggested, hey, is there an older, individual in your life who might be able to rent you a car? That's something that we could reimburse for. It wouldn't, be shocking to me if a very young and experienced parent kind of felt like, I don't have a car, I'm not old enough to rent a car, I don't know how else I would get myself to Oklahoma, so that's not really an option. And that was certainly an ongoing topic of conversation. I don't think it was something that parents quickly let go. The remote visitation with a child who's not even yet one was very challenging. It was something that was often discussed. So I think parents likely would have been open to other options had they felt like that was an actual viable alternative.
So what are you suggesting that the agency should have done under these circumstances with the travel ban and in the pandemic, more than what they offered?
Mm-hmm. Talking with parents about how they might be able to help them arrange for alternative transportation. If they said, hey, look, we will make it happen. We can't come to you, but if you can come to us, we will make it happen. And here's, XYZ of how that could happen. Maybe it's finding an adult, an older adult over 25 or whatever it might be to be able to rent a car. Maybe it's trying to figure out if there's a bus route that's operating during the pandemic where we could, piece together some different things. Maybe it's Uber. I don't know what it might be, but I think that at least trying to make them understand that there might be an option that's actually viable, is what parents needed. Because
it sounds like the way you interpret the active effort standard is you're placing all the burden on the state and placing none of it on the parents to ask any questions about what other transportation options would work, and having them ask even one question about, what alternate means would have been available.
I don't know that I would agree that all of the burden it would be on the state, because I do think that the parent has to at least have the willingness and the desire to cooperate in whatever those efforts might be, which the parents here, or at least mother here, certainly had. But if we look at the language, it really, at least the language that we have, the little guidance that we have, there is kind of this idea that it needs to be more than just saying, here's services, parent, but actually help them get those services. And that, sort of hand holding on some level, as long as the parents are willing to hold the hand and go there and do the work that is required of them when they're there. So again, I don't think it's completely on the state, but it is more than what we saw here and more than what we see in a typical SINC case. And again, I think what we saw here is really those reasonable efforts that we see in a typical SINC case. I would be interested in what, the suggestion is that rose above reasonable efforts or typical efforts in this case.
Are there any more questions at this time? Okay, you still have your rebuttal. Ms. Kuhn, we're ready to hear your argument.
Thank you, Judge. May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. What we have here is mother wanting this court to reweigh the evidence that was presented in the district court and look at it in the light most favorable to her. And that is not something that this court can do. The district court weighed the evidence, made credibility determinations, and the evidence here needs to be reviewed in the light most favorable to the state. Specific to the active efforts and the finding proof beyond a reasonable doubt that continued parental custody would likely result in serious emotional or physical damage to the child. This record is replete with evidence regarding first the injuries that happened to these parents' first child, unexplained serious injuries, and mother, we've heard a lot about her incriminating herself because of the also ongoing criminal case. But here, mother, from the very beginning, when that child was taken to the hospital, there was never an explanation given as to how he suffered those injuries. And when there's no acknowledgement, and even then further, when E.L. was born, I believe there was a statement that they didn't even believe that the previous child had suffered abuse. They didn't believe he had been abused. And so we're not even acknowledging what has gone on in the home and tried to deal with that, to make a change, to show that the home would be safe for this new child. So clearly it's our position that the state showed beyond a reasonable doubt that continued parental custody would result in emotional or physical damage. Then to the question of active efforts, I believe this court has hit on it, that it's the state, the agencies and the professionals here have to expend active efforts, yes, but you also have to have a parent who is willing to engage in those efforts, is willing to do the therapy that is a part of the case plan. And we have evidence here that the case manager went over the case plan with mother, explained to her that it was completely different from the case plan that she worked regarding the first child, explained to her the importance of completing those orders, let her know that there were low-cost options for therapy. I believe one of her arguments was at some point she quit therapy because she couldn't afford it. When in reality, she also quit therapy because she said she didn't want to do it. She didn't think it would help her, and she did not want to talk about what happened to her first child. So she quit therapy. The worker also provided her with phone numbers to community agencies to complete those orders, indicated what are free, what was on a sliding scale, attempted home visits, but was refused each time, which then ties into her visitation when not during the pandemic, never progressed to being in home because no one was allowed into that parent's home. Additionally, regarding the visits, there's been a lot made of the visits. No one could have known when this case started that we were going to walk headlong into a pandemic where travel bans would be issued and workers could not travel for visitations with this child. When the child was placed in the tribal foster home, the agreement was that that child would be transported, I believe, weekly for visitations. Then, of course, as we all know, pandemic hits and that couldn't happen. But the workers here, they were the ones that suggested the remote visits. They were the ones that continually communicated about where are we at with travel bans? Are we lifted? Can we start moving? And when those did ease up, then the child was brought once a month for 2-hour visits. Additionally, the tribe offered to reimburse for travel expenses and gas if mom could find a way to get to, I believe it was Tonkawa, so 40 miles, 40 minutes. I can't remember. It's in the record how far that would have been. And we also have information, evidence that her parents had a car. I know we keep hearing about how young the parents were in this case, but mother's parents had transportation, and she clearly had no issue getting to the things that she wanted to, be at work or the court orders that she wanted to complete, but did not take initiative when told that she would be reimbursed, did not take initiative to find a way to have more in-person visits with that child. So if you look at this record, it's our position that the professionals did expend active efforts, and there was clear and convincing evidence presented of active efforts. And I don't know what more these workers could have done when the parents refused or mother refused to do court orders, such an important court order as individual therapy to deal with what was going on in her home, which then ties into, there's nothing here showing that there was secondary change to know that this new child would have been safe in mother's home. And so we would simply ask the court to affirm, to find that the state met their burden and affirm this termination.
Thank you. Any questions?
No, thank you.
Thank you, Ms. Kuhn.
Thank you.
We're ready to hear from the appellant, Ms. Kiefer.
Thank you. I would note regarding the standard of review that we do know that here we have a higher standard. So we need to look at it back at the trial court's actions and ask whether or not that rational fact finder could have found evidence beyond a reasonable doubt, which is that higher standard than we typically look at in a sync case. And we have that heightened level of scrutiny here. And again, I've heard, evidence from the state that workers explained things to the parents. They gave them a case plan. They said, here are phone numbers. They said, here's information. And to my knowledge, that is very typical of any other state case. I don't see what efforts there rose above the active efforts or rose above the reasonable efforts that we typically see, and certainly doesn't rise towards those active efforts that I think that ICWA requires. With regard to the visitation in the parent's home, I know that the record kind of demonstrates that for a time that was very difficult because mother was living at home with her parents. So this is, maternal grandparents, and then they had some unwillingness to have other individuals in their home. I don't know if that was related to COVID or, what it might have been that caused the parents to feel that way, but that was certainly something that was an additional challenge to these young parents that was somewhat out of their control for at least a period of time. And, with regard to the visits, again, the pandemic has created challenges, in these types of cases, just as everywhere else, that certainly no one could have foreseen. And I do understand that a lot of things were just being done the best that they could at that time. However, we have testimony in this case from a variety of workers that visits are critically important to case progress. That if you have a case that is moving towards reintegration, that weekly in-person visits so that parents can demonstrate their parenting skills, so that parents can demonstrate that secondary change, so that they can, continue to show that bond with their children and develop that bond, especially here with such a young child. It's critically important to being able to assess the progress of a case. And whether it be COVID or not, that is still something that the parents here were entitled to, and mother did not receive whenever she needed to be able to demonstrate those parenting skills in weekly in-person visits. And so if that couldn't be accommodated, at that time in this case, then it might have been a situation where we needed to give the parents more time to be able to achieve those weekly in-person visits that all of the workers testified were so critically important to be able to evaluate the progress of a case and make recommendations for reintegration before terminating parental rights. So just like so many other things, we might be able to say, COVID has impacted this and that was out of the workers' hands. Well, we also have to choose how we respond to that. And that might mean responding to it a little bit differently, perhaps giving more time in certain cases to allow for those accommodations to eventually be made before we proceed to termination. So that's all I have, Your Honors. I actually, there was one thing that popped into my mind whenever we were talking about whether or not the parents had ever objected to ICWA. And I do know that the parents objected to transfer to the tribe, but eventually ICPC placement moved the child there. So there was at least some objection by the parents to the tribe's involvement and some of the ICWA implications at one point. But again, I don't know how relevant that is because it is the standard that we're stuck with now. So.
Are there any other questions of Ms. Kiefer?
No, thank you.
Thank you for your argument, Ms. Kiefer, and thank you for your argument, Ms. Kuhn. We will take this case under advisement and give you an opinion as soon as possible in this matter, because we know it's very important. Thank you for participating with us today.